Hey there, Justin here. Do you have a friend or a relative who's a little, okay, I'll say it, judgy? Maybe this person has serious opinions about movies, music, school, books, parenting, you name it. This person has something to say about it. Maybe that judgy friend is actually you. Nah, nah, of course not. Okay, let's just say for the sake of this lesson, it is you. It's okay. We need judges. Without judges, murderers could never be brought to justice. Criminals would get away with stealing, and arsonists could burn down buildings with no consequences. At the end of today's lesson, you will be able to identify the different types and reasons for jurisdiction, as well as analyze the overall federal judicial structure. Remember from Unit 2 that the Constitution says the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. In other words, the Constitution creates only the Supreme Court. The other smaller courts were created by Congress. Hopefully their plan works. We'll let you be the judge. Now, these other levels of the judicial branch did not come about without great and heated debate between the Federalists and the Anti-Federalists. The major issue revolved around jurisdiction. Rewind. Jurisdiction is the official power to make legal decisions and judgments. The Anti-Federalists wanted to limit the power of the federal judicial branch by restricting its court to appellate jurisdiction. That way, federal courts would mostly review whether the process of law was followed or interpret meaning rather than adjudicate fact or guilt. Word alert! Appellate jurisdiction is the power of an appellate court to review, amend, and overrule procedural decisions of a trial court or other lower tribunal. Remember, these courts do not rule on issues of fact. This decentralization of the courts would ensure that state court systems would remain important centers of judgment and thus interpretation of law. So, when you get your first parking ticket, you are funding, that's right, you got it, the state courts. In the end, a system of lower courts was created to hear a wide range of cases, but only have a regional presence rather than a state presence. At the federal level, these lower courts became known as district courts. Federal and state district courts would hear most cases and have what is called original jurisdiction. But this also means that for many cases, state and federal courts would have concurrent jurisdiction. Double word alert! Original jurisdiction means the first to hear and try a case. Usually this court looks at facts and declares innocence or guilt. Concurrent jurisdiction means that more than one court has the authority to hear a case. The federal courts are very, very important today. So important, it's crazy that not many average citizens know very much about them. Let's change that now. The Constitution grants exclusive jurisdiction to the federal judicial branch. Word alert! Exclusive jurisdiction means it is the only court to hear such a case. That means that the federal courts have exclusive jurisdiction over cases that involve multiple states, citizens from different states, ambassadors and public officials, foreign nations and treaties, admiralty and maritime laws. But when it comes to criminal and civil matters, many of these kinds of cases involve both state and federal law. In the past, many matters that dealt with regulations were historically dealt with at the state level. But as we saw in previous lessons, the big federal government started playing a bigger and bigger role in consumer and industrial regulations. So, This sometimes creates a situation in which it's unclear which level of government has jurisdiction in legal matters, which requires a concept such as concurrent jurisdiction and other processes to determine which level hears a case. Sorry, but you fall under our jurisdiction. So before moving on, I'm going to have to ask you to prove that you got it in a show what you know. In your notebook, please define jurisdiction. Next, define each type of jurisdiction. Why do we have each type? The structure of the federal judicial branch is certainly different now. District courts sit at the bottom of the system, and these courts have original jurisdiction in federal cases. Each district has at least one judge and one U.S. attorney, and that attorney or group of attorneys act as the prosecutor for criminal cases. And guess what? There are now 670 district court judges nationwide. Each state has at least one judge, but most states have many more. Also, each district has a separate bankruptcy court. Beyond the district courts in each state, there are 3 national or specialized district courts. These include the U.S. Tax Court, the U.S. Federal Claims Court, which deals with suits against the federal government, and the U.S. Court of International Trade. Next, there's the U.S. Court of Appeals. These courts review procedural issues in trial courts, not issues of fact. There are 12 regional or circuits. These are located regionally. Beyond this, there is one National Court of Appeals. The National Court of Appeals hears appeals from specialized courts on taxes, patents, and federal claims. Decisions for this court are made by a panel of 3 judges who have appellate jurisdiction. And then there's the high and mighty, the Supreme Court. Truly, it is high and mighty still. It is the highest court in the land. It contains 1 Chief Justice and 8 Associate Justices. It has appellate jurisdiction in most cases, dealing with law and issues of procedure. It is the court of final appeal. And yes, it still deals with those super important Constitution questions. The Supreme Court also has original and exclusive jurisdiction for disputes between states, for actions involving various public officials, for disputes between the federal government and a state, and for proceedings by a state against citizens or aliens of another state. Now that's a lot more power than it used to have. Almost done for the day. Ready to hang the robe up? Leave the old gavel behind? Sorry, but you're going to have to give one more whack to shut me up because I clearly love to talk. Oh, all right then. Let's get on with it. Please draw a large triangle titled Federal Judicial Structure. Create 3 levels. Label that top level the Supreme Court. The middle, the Court of Appeals. The bottom, district courts. Within each section, jot down the appropriate type of jurisdiction. Draw lines on the right and left side of the triangle. On these lines, write important information such as the number of courts, judges, and types of cases. Recap. Today, we learned the basic structure of the federal judicial branch. We defined jurisdiction and went over the 4 types. We looked at how the court structure has changed, which has resulted in a larger federal presence and changed the jurisdiction of district and circuit courts. Finally, we discussed the federal judicial branch's modern structure and jurisdiction. In the next lesson, we'll look at an important and controversial tool the federal courts use to interpret the law. I hope you enjoyed this judicious day. Have a great rest of this one. Goodbye. And remember to vote, debate, and participate. Hey, hey.